John Peter Zenger was a printer in New York City in the 18th century who was sued for libel by the British colonial governor. And he went to trial. He actually had a newspaper, I think, called the New York Weekly Journal. And he was sued by this governor that he was covering for libel. And then his lawyers went into court and asserted what is judged to be the first effort to assert truth as a defense against libel. And they said, you know, this may be damaging to your reputation, but it happens also to be true. And the jury acquitted him, and the judge let him go. And so that established, you know, something that lawyers would be able to describe more subtly than me, but it was a foundation for privileges that we still enjoy in this country for the moment. And so it is my great pleasure to welcome Cindy Cohn to deliver this year's Zenger Lecture in that spirit. And really there couldn't be someone whose work falls more squarely in that tradition of civil rights and the First Amendment. The Electronic Frontier Foundation, if you've never heard of it before, is like a mighty NGO in Washington that has been litigating and educating and advocating for many years, very foresightfully, about a whole suite of problems that have arisen in the digital age, surveillance most notably, and really fiercely advocating for liberty in this pervasive and kind of dynamic era of surveillance that we all share. I think, you know, they came to some attention after 9/11 when they really went after the government's surveillance regime, and that's still a very important part of their work. But of course, we all now work in a world of surveillance that has many frontiers. So Cindy was the longtime, I think, general counsel or chief legal officer of EFF, and now is the executive director. So I think she's going to stimulate us in lots of ways tonight, and really glad to have you here. So welcome, Cindy. Thank you.
Thank you very much. I'm really honored to be here. It's great. I will make one small correction. We are based in San Francisco, California, not Washington, D.C., just to demonstrate that you can have a vibrant NGO that is not in the Eastern time zone. So I want to talk to you guys today a little about journalists and mass encryption, mass surveillance and encryption. You know, journalists are really the canaries in the coal mine around mass encryption. You need security and protection for your work and also for your sources. My goal today is kind of twofold. First, I want to talk about the mass surveillance that's going on and give you hopefully a better picture of one of the key programs that I've been trying to get the courts to end for a long, long time. And also to talk with you a little bit about encryption technology, because if surveillance is the problem, encryption for many, many purposes is the answer. Often they get talked about as if they're in two different spheres, and I'm hoping today to kind of bring them together, because encryption is under attack, and in the United States and around the world. And I think people who are interested in journalism should see the fight to protect encryption as their fight, and not something that happens to other people over there. In case you think I'm the only one who thinks that surveillance and encryption go together, this is another guy who does as well. I will tell you that seeing that picture with an EFF sticker on his laptop almost gave me a heart attack in 2013. But it turns out that he wasn't nearly the kind of worrisome person that we thought he was going to be, and instead brought a lot of information to light that I'd been desperately trying to get attention to for a long time. When I say that, you know, surveillance is the disease and encryption is the cure, again, Mr. Snowden isn't the only one who agrees with me. This is a quote from a case that I handled in the 1990s called Bernstein versus Department of Justice, where we helped free up encryption technology from government control. And so don't take it from me, take it from Justice Betty Fletcher, that encryption is one of the tools that we need if we're going to protect ourselves from surveillance. Now, in the context she was talking about, we were talking about government regulations on encryption technology, but I think it's a very prescient quote because she doesn't actually say governments are the only people who can spy on you. She says prying eyes, which I think is very prescient in this time where surveillance can come from corporate actors as much, if not more, than government actors. I appreciate the kind introduction. How many people here have heard of EFF? Oh, wow. Okay. Well, we're going to solve that today. Who is EFF? Our organization, we're a nonprofit. We're based in San Francisco. We're an NGO, and our job is to work to make sure that technology supports freedom, justice, and innovation for all the people of the world. We have three kinds of tools that we use. Fundamentally, we're a bunch of lawyers. That is the center part, and we use impact litigation as a force because so many of the issues facing us in the digital age really come down to how we're going to interpret our Constitution. The First Amendment certainly central among those, but there's a couple other amendments in the mix as well. We also engage in activism, the kind of call your congressman kind of activism, and we build technologies, and I'll talk about a couple of those at the end as well. So this is who we are. And we've been around for a long time. We're the oldest NGO working on digital issues. We were founded in 1990. That's about 4 years before the World Wide Web. So, journalists, why do you need to worry about strong encryption? Well, I think this should be a pretty obvious slide. We really, both your sources are being surveilled, and journalists are being targeted now too. I just gave two recent examples off the top of my head. James Rosen and the AP, who had their phone records subpoenaed by the Obama administration, looking for leakers. And more recently, down on the border, we learned that the Customs and Border Patrol had made a hit list of people to be watched that include a whole bunch of journalists on the southwest border. And remember, the Customs and Border Patrol hit list is about who's to be targeted for surveillance as much as who's to be targeted to stop at the border. So I think it's pretty clear that you're in the crosshairs of mass surveillance if you're going to be talking to people who the government doesn't want to have a voice. So something happened after September 11th in the history of how the government thinks about surveillance. Prior to 9/11 and the Patriot Act and some of the stuff that came after, the government's approach was to try to figure out who was doing something wrong and then target them for surveillance. And what happened after September 11th is the technology became available and the government became willing to do something called collect it all. So this is a slide that comes out of the Snowden documents that shows the government's posture with regard to foreign collection, but I can tell you I have had conversations with folks in the NSA and the Department of Justice about the domestic implications of this as well. But as you can see, this is the circle. Sniff it all, know it all, collect it all, process it all, exploit it all, and partner it all, which is an important one for you to pay attention to because this has to do with the U.S. government's sharing of surveillance information with partners all around the globe, most specifically and clearly with what's called the Five Eyes. That is the United States, the United Kingdom, Australia, Canada, New Zealand, thank you, are the Five Eyes. And so that's a very tight, but the government has like circles of sharing of information. The tightest is with the Five Eyes. And that works both ways. So if the Australian government happens to pick up something that might be relevant to the U.S. government, they just hand it over. It's one of the reasons why domestic limit controls on surveillance in the United States only get you so far, right? Because of the way that the information sharing happens. So the specific kind of surveillance I want to talk with you about I call it internet backbone collection. The government also calls it upstream collection. And I want to be really clear that this is not the only kind of mass surveillance or targeted surveillance that the government is interested in, is engaging in right now. Another kind of surveillance that's also authorized under Section 702 is the statute that the government claims the ability to do mass surveillance under. A second program is called PRISM. I'm happy to answer questions about that, but let me explain the upstream first. But it's also not a business record collection, which is Section 215 of the Patriot Act, which is something you might have heard of when there was a big fight after Mr. Stone's revelations, and that program was scaled back dramatically. It's actually up for renewal in December of this year, so you should start to see information coming out about efforts by folks on my side of this conversation, try to get the government to drop it entirely, and other people on the government side trying to get it renewed. There used to be a mass internet metadata collection program that was stopped in 2008. There is foreign mass collection, which is authorized under something called Executive Order 12333. There is the sharing that we already talked about, including the Five Eyes, and then there's all sorts of targeted stuff. So while the systems that I'm talking about are tremendously important, and I think they're very dangerous, they are by far not the only ones. So here's a picture. I don't know if it's how easy it is to see about what the kind of surveillance that we call internet backbone surveillance looks like. So what I try to do in every talk is I try to give people a little bit of tech, a little bit of law, and a little bit of advocacy. So welcome to the tech section of this talk. So this is a drawing that my EFF has some staff artists made, but it's actually been confirmed by some of the internal documents that have been released about how internet backbone surveillance works. And let me walk you through it a little bit. As you can see, we have specific information in my lawsuit about AT&T customers, but so this is written for my judge, focused on the AT&T customers, but AT&T is not the only provider that is participating in the program. But so you have AT&T customers on one side, the places that they want to go online on the other side. How many of you are AT&T customers? Yeah. How many are Verizon? Yeah. They're both in the program for sure. So what happens when you send a message to somebody else or you visit a website is if you happen to go through one of the collection points, and those are generally close to the border, but not necessarily close to the border. We know about one in Atlanta, for instance, which last time I checked was not the border of the United States in any direction. But we have specific information about one of these collection points in downtown San Francisco, which actually, as the internet collection points work, is not the border either. The border for purposes of telecommunications is where the subterranean the cables come up from the ocean or the satellites come down, right? That's the border for purposes of telecommunications infrastructure. Neither of those happen in San Francisco or Atlanta, for that matter. So let's say you're an AT&T customer and you're going to a website that's hosted abroad, or you're emailing with somebody, and your communications are routed through one of these collection points. What happens is that there's a bank of fiber optic splitters. Anybody know what a fiber optic splitter is? Cool, I get to teach you technology. Lawyers don't get to do this very often. You know that your communications are carried on fiber optic cables. I suspect you've seen the commercials, right? A fiber optic cable is pretty cool because it's a beam of light. And cool science lets you carry communications on a beam of light. Fiber optic cable, what happens in the AT&T facilities is fiber optic cables go through what are called a series of splitters. A splitter is a very simple thing that splits the light in two. One of the cool things that happens to to communications carried on light when you split it in two is you don't get halvesies. You get an almost complete copy of everything that happens through the light. So a bank of fiber optic splitters sits in an AT&T building in downtown San Francisco, and as communications travel through, the fiber optic cables are split, and one copy goes across to its destination, and the other copy goes into the surveillance infrastructure. This is a really clever way to do mass surveillance, right? Because otherwise, if you had to check every packet along the way and try to figure out what's going on, you're going to slow down what happens on the internet. You're going to slow it to a crawl, and it's going to be fairly obvious that something is happening. But because of the way light works and fiber optic cables work, you can do mass surveillance without slowing anything down. So a copy of everything goes into the surveillance infrastructure in Folsom Street in San Francisco. That is room 641A of a building. We have pictures of this building from a whistleblower. And then once it's there, it gets filtered. The first filter is to try to get rid of purely domestic traffic, but that's actually really hard to do for some reasons I'm happy to go into if you want to. And then it gets searched for selectors. Selectors are whatever the government wants to search for. Generally, that's names of people, locations. You want to know everybody who went to the Al Jazeera website, for instance. You want to know all sorts of things could happen. And then everything that makes it through the selectors. So the first set of filtering gets rid of things like everybody's copy of Game of Thrones that's traveling over the internet too. And tries to get just to the stuff that they're really looking for. And then the second one is for the selectors. And then if it's on the selector list, then it gets caught into the government's massive databases. There's a whole bunch of these in Utah in a building that the government has collected. There's a couple other places where they store these kinds of things. So this is what mass surveillance looks like on a technological level. And this is the program that we say violates the Constitution. Now, again, this was built off of a whole bunch of slides. It was also built off of some government reports, including two authorized government reports that the Obama administration had done about mass surveillance. So we're pretty confident that if this isn't exactly how it works, it's pretty darn close. There are secret FISA court rulings that talk about this surveillance and other sorts of things. We don't know exactly if every detail is right, and that'll come up in a minute when I start talking about the lawsuit, but I don't think anybody disagrees with the general structure here. And again, you don't have to believe me. This is an internal slide from the NSA that also is part of the Snowden archive. This is the government telling itself what it should do if it wants to find some communications traveling over the internet. It says, first, you use upstream. That's the collection of communications on fiber cables and infrastructure as data flows past. That's just what I've shown you. Fairview, Stormblue, Blarney, and Oakstar are the code names inside the NSA for the providers. So I'm pretty sure that, I don't remember which one's which. Stormblue is Verizon or AT&T, and Fairview is the other one, I think. But I used to know that. And then the other one, which I mentioned briefly, but is also allegedly authorized by the same statute, is PRISM. And this is when they just go to Yahoo and say, search everything you've got and give us anything that's in this selector. That's a second kind of extremely important surveillance, but not the one I'm suing over right now. So what's included? What gets caught in this infrastructure? Well, anytime you talk to a person abroad, it probably gets talked. It gets there. Also, even if it's in a threaded communication, so let's say you're talking to somebody domestically and it gets forwarded to their friend abroad, that's going to get caught as well. Any packets that happen to get routed across the border. So the way the internet works, packets are routed. Your communication is split up into little packages, and they're packets, and they are routed, and they're routed based on efficiency, not based on national borders. So lots and lots of things spill over the borders that weren't meant to, and lots of domestic traffic that happens to go over the borders for one reason or another. One of the things that the government will argue is, well, since they just have selectors, and they only keep the stuff that is in selecting, they're not doing mass surveillance, they're doing targeted surveillance. And my view is that if you're actually collecting everything at the top and then saving what you want later, that's not targeted surveillance at all, that's mass surveillance. This is a fight, though, that's ongoing. And then once they get it at the bottom, they get to keep it, and they get to search it. These are some of the terms that they use. This is out of the government documents for when they get to search through the mass of things that they have collected. The most important one, I think, in the domestic legal context is what gets called backdoor searches. So once they collect it, then the FBI can search it for all sorts of purposes that are not just about foreign intelligence, what the NSA's normal hype is. And as I mentioned up here, they just got in trouble with the FISA court because the FBI wasn't even keeping track of why they were searching through the information at the level that even the secret, I mean, how bad does it have to be when the secret court tells you, no, you've gone too far? But anyway, these are the analysis and the reasons why they get to search this information. And then you, as the person whose information gets caught up in this, may never really know or be able to confirm that you were caught up into this. The government uses something called parallel construction, which means if they know something one way, they try to find another way to get that same information and then hide the fact that they got it in the first way. There's a great Human Rights Watch report about parallel construction. Or if you're a TV person, there's actually a really great episode of The Good Wife called Parallel Construction Bitches that I advise them on, that does a really great job of explaining parallel construction, where they've already got a lead on a guy and they pull him over, on a claim that his light was out in order to do a search, and then that's how they discover the stuff. So if your taste flows towards that, they actually do a pretty good job of it. They don't get the skiff right or a lot of other things, but they did get parallel construction right. There's no notice to you ever that this happens. Generally, if the government wants to use that information against you in a court of law and they've decided that they can't use parallel construction for one way or another, you will get a blank notice that says 702 evidence was used as part of this prosecution, without any indication of what kind of evidence or even what part of the Section 702 programs, PRISM or Upstream, were used. So far, nobody who's gotten one of these notices, by the way, they didn't give these notices at all until they kind of got caught by the Supreme Court, of where they said they were giving people notice and it turned out they weren't, in a Supreme Court case called Clapper that my friend Jamil Jaffer argued a few years ago. So they got busted. So they had to start giving some kind of notice. So they're giving the least helpful notice ever. And even then, when criminal defense attorneys have tried to get access to the information, to even get a little more information, try to argue that maybe it was unconstitutional, they've been denied any further information. So that's kind of what happens with this information. So how does this fit into the Constitution? Well, let's flip to the law part of this presentation. First, the Fourth Amendment. The Fourth Amendment was written in response to a particular thing that was happening in colonial America. What was happening was that in looking for people who were not paying their taxes or who were fomenting revolution, the government would issue for itself something called general warrants. This was not a warrant that was based on you individually or anything you did wrong or any particular person. It said, a crime has been committed, you are now authorized to go search for evidence of it. And with this, they would rifle through the houses of colonial Americans looking for evidence of a crime. That's what general warrants are. We'll go into them in a second. So when you're thinking about the Fourth Amendment, you have to ask, is something a search or a seizure? Because the Fourth Amendment protects you against searches or seizures. And if a search or seizure is found by the court, then a warrant is needed or some exception has to apply. Importantly, the FISC orders that the secret court issues in order to allow this whole structure to happen are not even remotely warrants. They don't identify an individual. They don't identify a place to be searched. They're general process warrants for a process. So this becomes very important as you try to analyze what's going on under the Fourth Amendment here. I talked a little bit about how the Fourth Amendment was based on what happened in colonial America. This is the grave of James Otis, who was a colonial-era lawyer who tried to fight general warrants, went all the way to England to try to fight them and lost. John Adams, who watched this trial, is quoted here above because he says that with the loss against general warrants, the child independence was born. That basically this was one of the last straws that led the colonial activists to decide that they needed to seek independence. So it's not a tiny little part of our history. It's a pretty important part of our history. So first step, remember I won't put the diagram up again, but the first step is, has there been a seizure? I argue that there's a seizure when they're making a splitter and making a copy of all your communications. You have a seizure means you have the right to dominion and control over your papers and your communications, and I argue that copying those communications is a seizure under the Fourth Amendment. The government says no. You don't. That's not about seizure. That the right to seizure only gets implemented if the timely delivery of your communications is interrupted. And since they're not interrupting it because they're just making a copy of it, there can be no seizure. There's cases involving contraband that they're referencing there. The other thing that they say is that it doesn't count because robots are doing it. Robots are doing the collection and robots are doing the searching. And so you're only protected against seizure and searches by humans and not by robots. And that the only thing that matters is whether they have a target or not the fact that they're searching through everybody's stuff in order to get to their target. So that's the government's argument. Then at stage 3, we argue that there is a search. When they're looking for their activities, there's a search. For a long time, the government was doing actually full content searching for things. So if you mentioned Osama bin Laden inside a message, that would trigger your message being kept, because anything that was about somebody on their selector list, and I think it's fair to say that Osama bin Laden was for a long time, your communication would be flagged and kept. In 2018, because the FISA court said that they were not doing that very well, the government actually stopped doing the full text about searches, but they still search the metadata, the to, the from, the where, the how, are you going to Al Jazeera, those kinds of things. Again, I'm going to try to give you a short version of the government's arguments. If you want to read the long versions, all the briefs are up on the EFF website, but I don't view it as my job to convince you that they're right. It's my job to convince you that I am. But the government says, no, this is just metadata. It's not content, so the Fourth Amendment isn't triggered at all. Also, they say the searching is done by robots, so seizing by robots, searching by robots, A-OK by the government, as long as robots do it. And that this is something like a dog sniff. So one of the things that the Fourth Amendment has an exception for is if you're carrying your stuff and a dog comes by and sniffs it for drugs. And they're likening their searching to a dog sniff because it only catches their selectors. It doesn't catch everything else. And so that's their argument in the kind of substance of the argument. Then the next thing that the government argues is there is an exception for special needs. This is the special needs exception in the Fourth Amendment. The government argues that national security is their interest and that should be a special need. There's reasons I'm happy to go into why I think that is not a credible argument for the kind of mass surveillance that they're talking about. Special needs is one of the things that they use when there's a checkpoint, say, and they're looking for drunk drivers, and they can stop you and kind of sniff your breath and stop you along your way, seize you in order to check for alcohol. I think it's very, very much to turn one of those kinds of targeted stops at one particular intersection in one particular town into the mass surveillance of everything that travels over the internet backbone at key checkpoints. Again, one of the government's arguments is that the breadth of the acquisition, since they're only looking for targets and those targets are foreign intelligence, it shouldn't matter the breadth of what they're doing. This comes out of some Washington Post reporting that was done in 2013, where they actually looked at who was being caught up in a tiny little sliver of the mass surveillance, and they discovered that 9 out of 10 of the account holders who were caught up in this were not the surveillance targets, but instead were other people, and that at the annual rate of targeting, basically at least 900,000 user accounts of people who are domestic would be targeted annually. That's in 2013. I actually think that number is too small, given the size of the surveillance at this particular point in time and how much more activity we all do online than we did in 2013. So the lawsuit that I have brought that we have brought at EFF to try to challenge this is called Jewel versus NSA. We started the predecessor case in 2006. This case has been going since 2008. And the arguments that I just gave you about why I think the Fourth Amendment should apply to these, we haven't even remotely reached them yet. And the reason we haven't reached them yet is the government is claiming secrecy over the whole thing. They're claiming that it would just damage national security too much to decide whether this surveillance that I've laid out for you based on all public information is legal or not. We're in the Ninth Circuit in that. We're in the middle of the briefing, and hopefully we'll get to a place where we can get to the merits of this case shortly. But that's where we are in terms of trying to get a constitutional decision out of this mass surveillance. So, how does mass surveillance relate to encryption? I'm going to try to go through this quickly because I really do want to have time to have questions. That's the most fun part for me. Well, encryption is, raise your hand. Do people know what encryption is? If I raise your hand? So, oh, great. So you didn't know EFF, but you know encryption. I am winning. That's great. Encryption is, for those of you who don't know, a way that you use essentially the old school science of secret codes to try to make something very difficult for somebody else to listen into. And you can do that with the content of messages, but you can also do that with the metadata of the messages if you're good, if you're careful at it. We don't do much of that right now, but the content we do. But why do I say encryption is the antidote? Well, encryption can block surveillance. So the government is caping all of this stuff, but it can't search through it for its selectors. It's not going to get anywhere that it needs to get. It really is the lockbox that will help protect what people do. Now, it has to work truly perfectly, and it rarely does. Your correspondence can still turn you in, right? If you have a communication with someone else and they hand it to the cops, all the encryption in the world isn't going to help you because they have to be able to see what we call the plain text. They have to see the message. That's why all the WhatsApp messages in some of the Russia investigation are well known and have gotten everywhere. It's not because they're able to break the encryption on WhatsApp. It's so that one side of the communication has turned it over to law enforcement. And again, metadata is still something we don't encrypt very well, but we're working on a few techniques to try to do that. So they still know who is talking to whom, when, and usually from where and what IP address, even if the content is encrypted. But it does stop some of the kind of driftnet phishing that you could imagine happens. I think about encryption as making the difference between the law enforcement phishing with a driftnet to collect it all and then sort out later what they need, and forcing law enforcement to really fish with a line and a pole and just get things one at a time. And in the end of the day, encryption has all around the world has saved lives. And the extra bonus with encryption is it actually helps create security. So all those data breaches, all that information that's leaking out of whether it's the government's accounting office or Target or Equifax or any of those other things, if that information is stored in encrypted form, then it's not very useful to the bad guys. So the nice thing about encryption is it gives us privacy, it helps protect us against authoritarianism, and it also gives us protection against the bad guys. For journalists, I think, again, a slide that should be obvious to you at this point, this is how you protect your sources, this is how you protect your scoops, this is how you get the information that then you give to the rest of the world. People who are able to give you that information and protect themselves are much more likely to give you the information in the first place. And you also don't have a legacy of sources going to jail on you, which is increasingly a problem. For journalists specifically, there is a tool called SecureDrop. Have any of you heard of SecureDrop? SecureDrop is a tool that allows anonymous sources to send information into journalist entities. I think it's a project of my friends at the Freedom of the Press Foundation, and has been installed in newsrooms all around the country and all around the world to help source information. To help somebody send you information without revealing who they are and without having it be immediately trackable. So this is, and encryption, by the way, is how Mr. Snowden was able to get the information to reporters without being caught out of the NSA. And there's a pretty famous story that he's relayed a couple of times, but most recently in his book, about how he tried to get information out first he thought about the New York Times, but since they sat on the mass encryption story for over a year after they had it and only published it after James Risen threatened to write it in a book instead, he didn't think that they could be trusted to actually publish the information. So then he tried to give the information to Glenn Greenwald, but Glenn Greenwald didn't know how to use encryption. And so they weren't able to communicate securely. So Mr. Snowden moved on to Laura Poitras, the documentary filmmaker, who did know how to use encryption. And as they say, the rest is history. Encryption is under attack right now, and the reason I want to tie these things in your mind as you're thinking about it is that I do think this is your fight. If you want sources to be able to get you information over digital networks or information off of digital networks that then you're going to use, you need to stand up for strong encryption right now. You need to join with us. So this is the part that's about advocacy in my speech. Attorney General Barr has just come out strongly against encryption. The FBI has been arguing that strong encryption is getting in their way for a long, long time. If you've ever heard about something that they call going dark, that is their argument about why encryption is so bad. I can give a whole other speech about why I think the FBI is not only not going dark, but they're kind of blinded by the light right now. They have so much information at their fingertips that they're having a hard time sorting through it rather than not being able to get what they need at the level they want. This was the centerpiece of the Apple versus FBI fight that happened a few years ago when the FBI tried to get Apple to break the encryption on the iPhone and Apple refused. Ultimately, the FBI backed down from that fight. But right now, the fight has really shifted. Not only is the FBI director pounding the table on this, but he's not trying to pass legislation. He's trying to strong-arm the tech companies into doing it for him anyway. By shaming them and frankly piggybacking on the techlash that's happening across the country and around the world. People are not very big fans of the big tech companies, and the Attorney General is trying to use that anger to get them to basically make you all less secure and to make it easier for them to dissuade and catch your sources. So you shouldn't be, while I think there are pieces of the techlash that are completely valid, and don't get me started on the surveillance business model and what it's done to our society and our world, you have to pay attention to, and so we should do X at the end of the Google and Facebook are really bad. And if the end of that is we should get rid of strong encryption, you should pay attention to the fact, because again, I think you're in the crosshairs of that, and we should do this. Australia and the United Kingdom have already passed rules that require providers based in those countries to be sure that they can access the content of every single message that travels over their network. We're seeing them slowly start to implement it, but they haven't much, and we've seen some companies leave Australia because they don't want to have to participate in that. We'll see if they're able to do it. Why are backdoors bad? I think the government's argument is that you can have all the encryption you want as long as we have a key to it, or we have access to a key to. I think there's a lot of reasons why that is tremendously dangerous. The most important is that we deserve the right to have a private conversation in the digital age. There's lots of other arguments as well. Another one that is pretty compelling when I'm in a different room, say over in the computer science department or the math department, is cryptography is applied math. And it turns out that other countries have access to math too. And even if you're not a government, you have access to math too. And so the idea that any single jurisdiction can ban math and have it stick is somewhat silly. And something we shouldn't buy into. It's not only that you can't ban math because math is all over the world. Math is a form of speech, and I think there are serious First Amendment implications for saying you can't put that math up on the internet because somebody might use it to keep a secret. That is, by the way, why I won that case that had the first quote on you, Department of Justice versus Bernstein. I won the argument that source code is protected speech, and that encryption source code requires First Amendment protection, and that the government's regulatory regime doesn't meet the First Amendment standards. So it's a tremendously important part of the conversation, but usually the one I emphasize when I'm in front of the geeks instead of the journalists. And then most importantly, and the one that Apple really applied, I think used very strongly, is if I say yes to you, FBI, how do I say no when the Chinese government or the Saudi government come looking for my customers' communications? Most of the giant tech companies don't even have a majority of their customers in the United States right now. So protecting end-to-end encryption is a journalist's fight too. I hope that I have convinced you. If not, I'm happy to answer questions. If you want to know a little bit more about how to use encryption, well, this is some of our other litigation work that EFF has done. We have two programs that are on this slide. One is called Surveillance Self-Defense, and the other one is called the Security Education Companion. Surveillance Self-Defense is actually a set of how-to instructions for various different people facing various different threats. But we have strains in there for journalists trying to protect their sources, both kind of journalists, really in the frontline sort of situation where perhaps you're up against a foreign government, but also in your day-to-day communication. So there's modules there if you're interested in learning how to do that. If you're somebody who already knows how to do that and you want to help teach others, the Security Education Companion is really lesson plans and other things so that we can share this knowledge and the people who learn it can also share it better. So those are two of the things that we do on the activism side that have specific tracks in that to try to help protect journalists who want to protect their sources. As I mentioned, EFF also builds technologies. Almost all of these technologies use encryption to try to help keep you safe. I'm happy to talk about the specifics of them, but they all have cool little logos and stuff. And so that we can get to the questions, I'll skip over that. I'm happy to talk about the other stuff that EFF does, but I'm happy to answer any questions. This, by the way, we borrowed Greenpeace's flying machine to fly over the NSA facility in Utah and try to draw some attention to the situation. Our friends at Greenpeace were very nice to lend us their little flying machine so that we could draw attention to the mass surveillance. So, any questions? All right, did I enlist you to my cause? No, go ahead.
We talked about secure drop in law this week, and our professor recommended against it because once someone puts a classified document in there, your only options are to turn them in or to commit a crime. How should we weigh that? Can you ask that?
The question is, if somebody puts a classified document into secure drop, journalists face a choice because receiving a classified document is itself a crime, right? Possession of a classified document, if you don't have the proper clearances, is a crime. Or turn them in. I don't know that secure drop lets you turn anybody in.
You have to give it back to the government? Is the only thing?
I don't think that's true. If it is, I will talk to them because they are my client and I helped create the organization. I suspect it is not at all the case that you have to turn them in. You can decide not to look at anything, and that's a choice you have to make, right? I mean, classified documents have historically helped us do lots of really good things when the public has found out about them, all the way from the Pentagon Papers and earlier, which helped end the Vietnam War, to Mr. Stone's documents, which helped us uncover unconstitutional surveillance programs. So I think depending on, you have to make a decision about whether you want to run that risk. Until Mr. Julian Assange, we never had a journalist prosecuted under the Espionage Act, and almost never had them prosecuted even for receiving classified documents. So we're in a bit of a new era with the government's willingness to go after journalists directly. And so I think that changes your calculation. But I would also say that, if you, again, I think to me, whistleblowers and people who are trying to get information out of the government are often the real canaries in the coal mine, right? They have really served society. And so to me, the effort is better spent trying to get those whistleblower protections to the place where they protect people like that. And they allow people to give stuff to journalists than to be afraid. But I'm not going to tell anybody what they should do. But I would be surprised beyond all belief if secure drop had an easy way for you to report somebody to the cops. I'll be I'll be texting them right away. But, Freedom of the Press Foundation creates Secure Drop. The chairman of the board of the Freedom of the Press Foundation is this guy. So I feel pretty confident. There was another question. Yeah. Yeah, in the back. You. Up to you. Or you can go to the mic or I can repeat it. Depends on how long it is.
You talked a little bit about metadata encryption, and I was wondering whose priority is that? Are tech companies interested in encrypting metadata, or is that something that individuals need to do themselves?
Well, individuals can't do it themselves right now in most situations. It is something that we in the nonprofit sector are continuing to work on, and there's actually a lot of academic interest right now. But, until we fix the surveillance business model, right, it's going to be pretty hard to get the big tech companies to do it. But some of the folks who developed Signal, if you've used the chat program Signal, have been trying to figure out how to solve this. It's a tough one, right? Because some of the metadata is used for routing, and so the computers along the way have to know where things are going. But one of the things that is really helpful for metadata protection is something called Tor, the onion router. So Tor, I'm on the board of the Tor Foundation. Tor is a way where if you are going to a website, you can go through a bunch of other servers so that by the time you get to the website, even if it logs your IP address, gets the last one in the thing and not yours, right? And this is used by human rights activists all around the world. It's used to get information out of very dangerous areas. Reporters use it. Ironically, it was developed by the U.S. Navy because it turns out spies need to hide where they're going. But it's an open source project now. You can read all the code. It's completely not controlled by the government anymore. But that's one way that people can protect metadata. It doesn't help you in every situation, but it can help you in those situations. But right now, there's some academics at Stanford and some other people who are trying to figure out how to better protect metadata. And I mention it because I want there to be more attention to it, and I want more people to start demanding it, because I think that it needs to move out of the ivory towers and into kind of things that people can use.
Hello. I was going to talk about Signal because Signal is free, and usually when something is free, we're told that we are being the product. And so I don't really understand how Signal can make money without making money on our back.
Mm-hmm. Signal's a nonprofit. Signal is not making money. Zero.
So
In fact,
how do they run the app? They have to update the app. There's constant.
No, but it's a charity. Right, so Signal is supported by foundations. It's supported by a huge grant from the guy who created WhatsApp, who left Facebook with his millions of dollars and gave it to the Signal Foundation to continue to support Signal. So Signal is a nonprofit, just like Tor is a nonprofit, and they are supported by charitable donations, and they don't have a business model. So that's why Signal is free. Signal was created off of, it's interesting, I don't want to get too deep into this, but Signal was a protocol that was written by academics out of the University of Waterloo and some other place. So this idea that things start in the academics and it has to make it out of the ivory tower, Signal works on a protocol called OTR, off the record, that then was ported over and Signal was turned into a user. So what the Signal people did was take a secure protocol and make a pretty front end, so you can use it. You don't have to know a lot of, unlike using something like PGP or something, you don't have to be particularly technical to use Signal. And then WhatsApp, the founders of WhatsApp, really liked the Signal protocol. They developed another front end for it, which is what we know as WhatsApp, and then sold that business to Facebook. So the WhatsApp guy taking the money and pouring it back to the Signal Foundation is really just him supporting where it came from, right? So Signal's a nonprofit. If you ever see Signal turn into something that's not a nonprofit, then you should begin to be worried. But it is a secure protocol. It's open source, which means that other geeks can test it, and it doesn't have a business model. And so that's why it's trustworthy.
Okay, great. Thank you.
Mm-hmm. WhatsApp is also end-to-end encrypted right now, and but what they do is they try to make money off of the metadata, right? Who's talking to who, and they're in the process of trying to combine Facebook Messenger with WhatsApp with there's a third one. And there's a big question about whether they're going to make that all encrypted or make it unencrypted like Facebook Messenger is. But I think their business model is to try to figure out who's talking to who and place the ads based on that and keep it encrypted for reasons that have to do with wanting dominance in the messaging side. I don't, and maybe out of the goodness of their hearts, but I wouldn't bet on that. But right now, for people around the world, I often get this question because WhatsApp is owned by Facebook, is WhatsApp end-to-end encrypted? And it is right now. And I think it's pretty secure, again, because we know what it's based off of. But you're still in the Facebook world, and they're still trying to monetize who you're talking to. So I still prefer to ask people to suggest that people go to Signal because it doesn't have a business model. It's a nonprofit. Any other questions back?
In your list of activism, there was a line that said street surveillance.
Yeah.
What is that?
We call it street level surveillance at EFF. This is the kind of work that we're doing to try to stop the everyday surveillance that cops are doing. So facial recognition, automatic license plate readers, biometrics of all kinds. We know that at the border they're starting to collect DNA of people who are seeking asylum, and that's not quite street level, but close enough. So we do a lot of work trying to make sure that the Fourth Amendment applies and that the warrant requirement applies to all of these new kinds of mass surveillance, which are much less rooted in national security and more rooted in cops. We're actually making pretty good progress in terms of the constitutionality of those. There's a case a few years ago called Jones, where they found that the cops had to get a warrant in order to put a GPS device on your car. And then just in 2018, the Supreme Court agreed with us that the cops need a warrant if you get arrested and they want to search your cell phone incident to arrest, they need a warrant to do that. That's not just something they get to do. So we're making slow progress on that and on the kind of constitutional level, but the cops keep getting more and more ways to do mass surveillance. So right now, EFF has launched a campaign against Ring, the doorbell people. It's owned by Amazon, where the Ring doorbell lets you put a camera on your doorbell that then looks out to your community. People want those for personal use. We're not all that upset about it, but they've entered into over, I think it's like 200, I think maybe close higher than that, agreements with local chiefs of police. So that the cops will come around, try to market for you to get a Ring database, and then once they do, the law enforcement then will ask you to opt in to sharing your footage with law enforcement. And if you know anything about how surveillance works, like this is tremendously bad for people walking along the street, right? You don't have privacy anymore. Now it's opt-in. For you to share your information with the cops, but the cops have a map. They know where all the rings are. They can put other kinds of pressure on you. And if you won't do it, they can just go get a warrant and get the information anyway, because you have helpfully provided a video of all your neighbors and all the workers in your neighborhood and all the other people in your neighborhood. The camera doesn't point in, it points out, right? It's the same with police cameras, right? I mean, we're learning this, right? For a while, everybody was like, oh, cops need to have cameras. And then after a while, we got cops all having cameras, and we learned, A, cops can turn them off, and they do. And B, that footage isn't available to defense attorneys, and cops look at it first. And so it's ended up not being the kind of accountability thing that we thought it was. What has become an accountability thing is our cameras on the cops, right? When we can turn the cameras at the cops, we get accountability. When the cameras are on the cops and they're looking out at us, we don't get accountability. The same is true with doorbell cameras, in my opinion, and we're going to learn all this. But so street level surveillance is all of this stuff. We used to call it, my colleague Jen Lynch is a lawyer who is my surveillance activist, and we used to call it Jen's scary shit part of our practice, but we decided to call it street level surveillance because that seemed to be a little more presentable. So.
Are so-called burner phone conversations subject to data collection and surveillance? And I believe the technology would not be fiber optics for that communication.
Most burner phones are going to, most cell phone communications get turned digital and they go over the internet backbone now. So there was a time when the phone systems were pretty separate from the digital systems, but most of the phone companies now it'll be cell phone to their main switching session, but it's so much cheaper to have those communications travel over the internet that they turn them into packet switched. They turned it into like voice over IP, right, was the original one. So I think for a burner phone, it may be harder to track back to the person, right, because it's not registered to you. And so that can give people, especially against domestic and local law enforcement, that's why burner phones were very useful. You know, if you ever watch The Wire, you know about that. But if you've really got a sustained targeted thing, it's pretty hard. And one of the things that they do with burner phones is if you've got a burner phone, if you've got a phone and you call a certain number of people, they'll kind of catch the profile. And so even if your phone goes away, the next phone that comes up on the network that starts calling all those same people, I've watched people go to jail for this, right? Like this is so they have other techniques to try to get at burner phones, and the calling circle information is the one that I've seen them. They've been willing to talk about it in prosecution. So again, depending on your threat model, depending on who's coming after you, a burner phone could be a helpful thing. But against somebody who is really aiming at trying to surveil you, it's only going to get you so far. Yeah, how does this work with things like Alexa, the Amazon one, or the Google Home things, the Internet of Things stuff, or the Internet of Surveilling My Home things? Yeah, so first of all, those things have to be listening in order to hear the open word, right? So when they say to you, well, it's not listening when you're not talking to them, that's not really true, right? Because if you say Alexa, it has to hear you. So they're listening all the time, and you have to trust them that they're not, and they keep a buffer usually of so they listen. They don't keep it forever, but I don't know how long they keep it because they're not releasing it, but it would be a lot to try to keep it for too long, unless they had like an order from a court that says turn this on and keep it for a long time, which you can get an order from a court to do that. So they're listening all the time. Their security is okay on them, but there is a big worry about it. There was at least one case in Texas where they claimed to have solved the crime based on Alexa. I think that evidence is a little flimsy, but law enforcement certainly has a very big interest in that information, and they probably need a warrant for it, but there's a fight that's going on now. I'm going to get a little into law. There's something called the third-party doctrine in the Fourth Amendment that comes out of the 1970s. The third-party doctrine is a part of the Fourth Amendment that says that if you have some information that otherwise would be protected, but you give it to a third party, then you've waived your Fourth Amendment rights to it. And it comes out of a couple of cases. One is called Smith and one is called Miller. One of them is about telephone calling records, and the other one is about bank records. And the Supreme Court in both of these instances says that once you consent to have a third party have your information, you've waived your Fourth Amendment rights in it. We chipped away at that in the GPS case and in the search incident to arrest case, the Carpenter case that I talked about, but nobody quite knows what the parameters are still. I want to kill it dead, the third-party doctrine. But that raises the question, right? If it's not in your house anymore and Amazon has it, have you consented to give up your Fourth Amendment rights in it because you let Amazon listen? We have not had this come up in a court case yet. In the Texas murder case, they had consent because the family of the person who was killed had consented to the information being turned over. But I think we're going to see a case pretty quickly about this. And I think it raises a question about whether a warrant is even enough protection now that they can literally have access into anybody's home at any time. Is the warrant standard actually high enough of a standard to really protect people anymore, given how easy it is to get a warrant? But that's another presentation for another time. Yep.
So it's recently come to light that our phones are listening to us and things like that. I mean, I have firsthand experience. I remember talking to my roommate at length about banana bread that I was going to bake, and later she came to me in a panic and she says that their ad are being advertised too. It's happened to me before, and I know it's kind of like a tinfoil hat moment, but it really is. I find it really creepy. So I'm curious to hear your thoughts about that.
So there is a lot of people who are feeling this eerie thing that I had a conversation about something, say banana bread, and then I start seeing ads for it. I will tell you that so far, it's really not possible for them to do real-time ad placement based on voice calls. They'll get there, but they really can't do that now. That's the good news. The bad news is you probably did something else. Honestly, they are so inferential about things that the chances are that they know anyway, based on other things that they do have access to, is really, really high. I had my techs do this a couple of times, and we tested it out. And pretty much all the time, there was something that somebody did in an email, in a chat, in something other than a voice call that probably went into the ad placement. So it's, I guess, somewhat good news for your voice conversations, but really bad news for your text, right? Especially if you're using something like Facebook Messenger, which is absolutely used by them to place ads. So it's kind of I don't want to side with them because I think that your reality is probably largely true. It's not true in this tiny little place, and that's just because they can't figure out how to do it yet. So I think it's creepy, and I think, this is the other thing that I usually hit in my notes, but I didn't this time, is that, one of the things that people ask is, well, what can I individually do to protect myself? And there's some things, there's Signal, there's Tor, there's other things you can do. But honestly, this isn't if you buy the frame that this is something that you individually have a responsibility to do, and you're failing if you don't do it, and that's where it goes. You're missing what's going on. This is a societal problem. We need to do societal things, like change the rules and change the law and change the cultural expectations around these kinds of things. We have to do group things, not individual things, if we're going to reclaim our privacy right now. And there are things happening, right? Europe passed a general data privacy regulation. It's got some good things in it. It's got a couple things I don't like in it. But in general, at least they're trying, right? We can't even get, we passed a pretty strong law in California. It was a bit of a mess. And now the tech companies are running to Washington, D.C. to try to dumb it down. So there's all sorts of there's a whole couple other talks I could give about privacy and why we need to think of it as a team sport and not an individual responsibility. If we're gonna stop it, it's not right to put this. I mean, it's what I tell people is it's kind of like what if you went to go buy a car and then somebody handed you a manual and a bunch of slides and told you to go to a presentation about what brakes you should have. And you were individually responsible for picking out your brakes. I mean, how could you not put brakes on it? How irresponsible you would be. You'd have, first of all, a whole bunch of people driving around without brakes. And secondly, shouldn't be your responsibility. Having good brakes should be part of having a car, and it is, right? They're required to put brakes on your car. I think having security and privacy should be a requirement of giving you a communications technique in the same way requiring brakes is already on your car. Yeah, I don't know when I'm supposed to stop, so you give me the high sign. Okay.
In this privacy debate, how much is it a national thing and something international or global? Because I get it in the United States, but then you have China developing all this stuff
Yeah, how much is this domestic and how much of it is international? It's plainly international, and China is a really good example of a place where, they don't have, they not only don't have rules, they have a governmental policy that is really aimed at maximum surveillance of people. And it's not just a government policy, right? There's a whole cultural thing that happens there. A lot of the people who get turned in and this stuff are not turned in by the cops, they're turned in by other people. So this is an international problem. The right to privacy is not, it's not a local statute. It's in the international human rights things. One of the things I mentioned here is the necessary and proportionate principles, which is a set of international principles that EFF worked on with a bunch of groups all around the world about surveillance, and when necessary and proportionate is the international law term for when governments can surveil. So this is an international fight. And we join it in many places around the world. We don't have a lot of leverage in China as a U.S.-based NGO. So we try to, talk about that stuff a little bit and do what we can. But in general, that's we just try to be supportive of the other organizations and people who are fighting there. But all around the world, this is fight. As I said, Europe is ahead of us in thinking about legislative strategies around commercial privacy. They're actually not all that great on governmental privacy, but the South African Supreme Court just ruled that mass surveillance was illegal under South African law. There's a case called Big Brother Watch in the EU that was kind of a mixed bag. So these conversations are happening all around the world, and rightfully so. I think that, as Americans, we're the place where a lot of this technology comes from. And for me, certainly as somebody who lives in San Francisco and understands and cares a lot about tech, I feel a special responsibility. And my organization was founded to try to make sure that technology supports free speech, privacy, and innovation, or freedom, justice, whatever, all those words. So we feel, I feel a special obligation, and I think as Americans we should feel a special obligation because we have been the generators of a lot of this technology, but certainly not the only place. And certainly if your guys are going to be foreign correspondents and you're going to work around the world, these privacy issues are paramount. They're paramount because, in the United States, you might get your source arrested. Around the world, you might get your source killed. And I can't be the first person who has told you those stories, but we have helped people all around the world and seen, what happens when it goes wrong. Sorry about that. This is what I do. Thank you very much.